Hi, everybody, and welcome to the Kevin Davis Insurance Top D&O Claim webinar. I'm Marketing Manager Sherry Branson. I have a very special guest today. I'm joined by Travelers Associate Claim Executive Rachel Plzak. Hi, Rachel.
Hi, Sherry. How are you?
I'm doing well, thank you. Doing well. And Rachel, this is our annual claim webinar. We've been doing it for the past several years. Every September, this is our tradition.
Yep, this is our
Here
fall.
we are. The fall tradition, and this is 2020. And we have some new people joining us today, Rachel, who haven't been on the claim webinar in the past. So can you talk a little bit about your background with Travelers and how long you've been with the company and that kind of a thing?
Certainly. I have been with Travelers for 18 years now. I started with the company actually in their New York office handling global marine claims for about the first 3 years of my career, and then transferred to the Hartford office and have handled D&O claims ever since.
Oh, okay, great. And what do you like to do for fun when you're not at work?
Let's see, running, doing the Peloton, baking. It's a good time to bake pumpkin muffins now.
Absolutely,
So,
absolutely,
yeah.
yeah. Fall foliage is out. I'm sure it's starting in your area. Rachel's up in New England where it's getting a little cooler, a little more fall-like.
Yep, the leaves are
Mhm.
changing already.
Great, great. Nice time for hiking and being outside and getting
Mhm.
pumpkins, etc. Fantastic. Well, welcome. Thank you for joining me
Thank you.
today. I really
Thank you.
appreciate it. And I do want to mention that I record all of our webinars and I put the recordings on our website, which is kdisonline.com, where you can listen to today's webinar whenever you have time. And all of our past webinars are also on our website, which is kdisonline.com. And today's PowerPoint presentation is uploaded as a handout. If you look to the right-hand side of your screen, you'll see a Handouts tab. Just click on that tab and you can download today's PowerPoint. So thank you very much. And now let's see, if you have any questions during the webinar, feel free to email them to me. My email is sbranson@kdins.com. And now we're going to go to the next slide, which is a disclaimer, which if you can take a second to read this. If we could advance to the next slide, that would be good. Okay, great. Thank you very much. And I want to talk a little bit about our goal today. It's to talk about the top claim trends that are happening in the community association industry. We're going to talk about basically, just a basic definition of what is a claim. It's basically a written demand for monetary, non-monetary relief, a civil proceeding commenced by service of a complaint, criminal proceeding commenced by an indictment, a formal administrative or regulatory proceeding against an insured for a wrongful act. So that's your basic definition of a claim. And now we're going to talk about 4 basic topics: D&O claim trends that Rachel is seeing and that we're seeing at Kevin Davis, common claims examples that are happening in community association industry because it's a very unique industry and we know you all work in that industry, and then common policy exclusions. And then I'm also going to talk about a great resource for your customers. You'll definitely want to get the phone number for this. There's a special risk management helpline, which is available free of charge to travelers insureds. So we're going to talk about that at the end. So basically, the D&O claim trends that Rachel and I discussed prior to the webinar that we're going to discuss today are non-judicial foreclosures and comfort pets. So let's start with the foreclosures, Rachel. Can you talk about that a little bit and what you're seeing there?
Certainly. What we tend to see are claims that are arising out of non-judicial foreclosures. There's two types, 2 avenues for proceeding with the foreclosure. One is a judicial foreclosure where the court controls how it goes, and the other is non-judicial foreclosure where typically the association will hire an attorney, but all of the various letters need to be sent at various times. Specific dates are given for different things that need to happen. It needs to be very precise. And if any one thing is done incorrectly, it can invalidate the foreclosure and it just becomes a very expensive type of claim. Typically, if you have a foreclosure that was done improperly, you have the person that has purchased the property and has moved into the property, and then you have the person who has lost their property, and both sides want their property. So they can become very messy. And in my professional opinion, mind you, I only ever see the ones that have gone wrong. I would suggest that judicial foreclosure is the safer um, route to go, in my opinion. So,
Hmm. That
but I'm
makes
just a
sense. I
claims
mean,
handler, not an attorney. So,
yeah, I'm sure the associations will be thinking they'll save money by doing the non-judicial, right? It's probably less
Mhm.
expensive in the beginning, but if it turns into a large claim, it could end up being more expensive.
Exactly.
Hmm.
And I will share that the the claim that stands out most vividly to me was one where it was one of the letters that needed to be sent to the person who was being foreclosed upon. It was supposed to read that they had 60 days from the receipt of the letter, and instead it incorrectly said 60 days from the date of the letter. And that distinction undid the foreclosure.
Oh, incredible.
So,
So just
I
one
mean, it's
word.
it's a really, very detail oriented process. So again,
Hmm.
I would say judicial foreclosure is the way to go if you're going to
Hmm.
foreclose.
Absolutely. Yeah, that's a safer route to go, much safer. That makes a lot of sense. If one word could do that, then I
Hmm.
think that's a great recommendation. Great. And we're seeing all kinds of stories in the news, and we're hearing more and more situations regarding comfort pets. And it can be a variety of animals. It could be, I mean, it's not just cats or dogs or your typical pets. There are a lot of unusual pets out there. What are you seeing in that area?
So usually it's either service animals or emotional support animals. And the claims that we get, I will say that the administrative agencies tend to be very liberal with their findings. It's usually in favor of the person who's bringing the claim. It usually comes in as a discrimination complaint, ADA complaint, um, and people are able to get documentation to say that their animals are service animals to try to persuade the boards to let them keep them. Um, so I understand that there are associations that are um, animal free, no animals, and this is sort of a point of contention with people who have purchased, units with the expectation that they won't have to deal with, fill in the blank, barking dogs or people not picking up after their animals or, um, but so I understand that the boards feel very conflicted about what to do. They're sort of serving the people who they're serving everybody, but you have a group of people who don't want any animals, and you have a group of people who are saying, I need an animal because I have a disability. And I would always recommend that they consult with their general counsel. Um, and in my experience, what I can say is that I would say 9 times out of 10, we're seeing cause findings for the people bringing the claims for um, their service animals or emotional
Oh,
support animals.
that's interesting.
Yeah.
So regardless of what the CCNRs are at the association regarding no pets allowed
Yeah,
or a certain size of dog or even a breed of dog, that really gets
correct.
overturned.
So the
The right to have comfort.
CCNRs, yeah, the CCNRs will be the roadmap for how the association should be run. But if you have state laws or federal laws that differ from what those CCNRs state, those state and federal laws are going to trump what it says in the CCNRs.
Mm,
So
excellent
yeah,
information.
even if it's no pet,
Mm,
house or
yeah.
association, if federally they're entitled because they have a disability to have an animal, they're
Hmm.
entitled.
They'll have, yeah, they'll be allowed to have their animal. Okay, that's very good to know. Excellent to know. It does not matter. Okay, great. And now we're going to talk about one of the more common claims that you see and that I see and that a lot of us see in the community association industry, breach of fiduciary duty. We have a situation where a board president hired a friend to do the landscaping for the association, even though his friend's company was much more expensive than the other bids that came in. So this turned into a claim. So can you explain why this would be a claim, Rachel, and what the problem is?
Absolutely. So when people run for the board and are elected to the board, they're basically making a promise that the decisions that they make are going to be in the best interest of the association and not in their personal best interest or in the best interest of a friend or relative. In this case, the decision that was made benefited a friend, not necessarily, well, not the association. So they breached their fiduciary duty in this case, um, which led to a lawsuit.
Absolutely. Yeah, it actually, there's a lot of responsibility as a board member to be fair and to not give jobs to family members or friends, etc. And that, you don't want that perception that there's favoritism and that you're not doing what's in the best interest of the homeowners at that association.
Exactly.
hmm
Exactly.
We mentioned the CC&Rs earlier, and basically that's the bylaws of the associations, the rules that the homeowners have to live by. And there's a claim that we saw where the board held a meeting without providing proper notice to the homeowners. And at the meeting, they had a vote on a new expenditure that, per the association's CC&Rs, required a two-third unit owner approval. They didn't have enough unit owners in attendance at that meeting to get the two-third vote, but they held the vote anyway, Rachel. So why is that a problem, and why did that turn into a claim?
So the CC&R set forth how the association will be run, and it's, everything. How many people sit on the board? How many days notification do unit owners get before a meeting is held? Um, they need to set forth what's going to be discussed at the meeting. If there's going to be an expenditure above a certain threshold, how many unit owners need to vote on it, excuse me, and how many, they need to have a two-thirds vote in their favor to pass such an expenditure. If they don't get that, then they are not complying basically with the rules that have been set forth to run the association. And yeah, that's, they're violating basically the contract that they have with the unit owners who buy into the um, association or townhouse or whatever community it is. So that will become a claim or can become a claim.
So that's why there's so much responsibility on the shoulders of the board members to be familiar with the CC&R so they don't do something like this. They know
Exactly.
what are in the rules, what do they have to abide by when they're holding meetings or sending out notices, etc.
Correct.
Great. And now another claim area that we see a lot of claims in, and associations are signing contracts every day, Rachel, with landscapers, with painters, with all types of contractors. And we saw a claim with a breach of contract claim where an association hired a landscaping company for a 3-year contract. After 1 year, they decided to fire them. They thought the work wasn't up to par, and then the landscaper sued. So I'm sure you've seen lots of situations like this happen because of so many contracts being signed every day.
Correct. So it usually comes in sort of one of two ways. You either have a board that's unhappy with the work that the contractor is doing, or you have a new board that is elected and they go through all of the contracts and decide that if they like them or not. I mean, I've had claims where the new board comes in and didn't care for the way that they landscaped, so they fired them, terminated the contract, and got someone else. In each contract, it usually sets forth what needs to be done in order to terminate the contract. And lots of times, you know, people have not, the board hasn't gone through and read the contract carefully enough to see what those conditions and terms are. Another point I would make is sometimes people are, or boards rather, are unhappy with the work that's being done, but haven't kept track of what they've been unhappy with, if there have been service calls that haven't been answered or something to that effect. So two recommendations that I would make would be, A, if you're in a contract and you're unhappy with the work that's being done, consult your general counsel to make sure that if you are going to terminate the contract, that you're going to do it in accordance with the terms set forth in that contract, as well as keep track of what you've been unhappy with, what they have done wrong. So
So you're
those two
talking about
things can
a
help.
paper trail.
A
You're
paper
talking about
trail, exactly.
a paper trail. Yeah, so document basically if the landscapers or the painters or whoever it is, document what's happening along the way and keep it in a file.
Correct.
hmm Great, fantastic. Great advice. Fantastic advice. And now another situation that I know you see and that I see as well is there are a lot of people who have special considerations in an association, but we did see something that where a member filed a lawsuit against the association and the board president because they refused to recognize the person's disability and allow them the accommodation of an emotional support animal, which is what we talked about earlier. So basically, they attempted to mediate the claims several times. However, they could not come to an agreement, and it ended up going to trial. So this, they were working back and forth, trying to work it out, and for whatever reason, it just didn't work out.
Mm-hmm.
So associations have
These
to be
become
aware.
very difficult because um, can you hear me?
I can hear you fine. Yeah. Can you hear me okay?
Okay, I
Yeah.
can. Sorry about that, people.
That's okay.
I
You
was
just
going to
raised
say
it.
this becomes sort of very expensive and very time consuming. In this example, which we've sort of already discussed, we're talking about an emotional support service dog. These also come in frequently in New York, where people don't have wheelchair access. And we're seeing this even on buildings that have commercial units on the first floor, and we'll have people who are unable to get into a store, and they will file an ADA complaint,
hmm
Americans with Disabilities Act, and
hmm
usually the building gets brought in as, the owner of the commercial space. And it becomes very expensive and very it takes a long time to get these matters resolved. Once it gets into litigation, if if matters can be sort of resolved pre-litigation, it's much better in my experience. Try to figure
Absolutely.
out an accommodation that works for everybody.
Well, what just this kind of highlights to me, not only do the board members need to be familiar with the CC&Rs, they also need to know about federal laws such as the ADA, et
Hmm.
cetera. And they really need to know a lot. Or if they're not familiar with all of the laws, speak to their counsel on a regular basis as things
Speak to
come
the
up.
council. Yeah. Another one that is almost frustrating is there's familial status discrimination,
Mhm,
and this
mhm,
is the claim I had, and it's my claim that I say was frustrating, not the actual status. Um, it was a board that had a pool within the association, and they were trying to set forth some rules. And within the rules, they were setting um, guidelines that children needed to know how to swim, um, and they were met with a discrimination lawsuit based on familial status, that the children weren't being afforded the same opportunity to use the pool as everyone else. The board's response was, we're trying to protect the association from a liability claim, because if someone doesn't know how to swim and they're unattended, that can have dire consequences. So that was a situation where the board was really caught in a hard place, because either decision could result in a lawsuit being brought against them.
Right. Yeah. They're just trying to protect the homeowners and protect the safety of the people living there so that they feel they're doing a good thing, but that could also be turned against them. Hmm.
Correct.
And quite a
Or
few
perceived differently.
perceived differently. That's exactly. Yeah. And a lot of associations don't have lifeguards on duty. They don't have, so you can understand where they're coming from,
Yep,
thinking, hmm
absolutely.
for
Thinking that
safety.
they're protecting people.
Hmm. That's, yeah. Yeah. So you never know. Hmm. So that's an
Correct.
example of a discrimination claim. And I did want to mention one more time that if you'd like to download today's PowerPoint, feel free to click on the Handouts tab, which is on the right-hand side of your screen, and you can download the PowerPoint with all of these examples. And the next claim example, Rachel, I know you handled this one yourself. This is kind of a unique one that I'd never seen before. Um, it's improper towing and conversion. And if you want to talk about this one, you can tell the story of this one. It's very unique.
Certainly.
I've never seen this before.
Certainly. So yeah, it was a family that had a unit within an association, and I believe it was their daughter who went off to college and left her car parked at the association. And after, I believe that the car alarm was going off intermittently, and that was part of why it was becoming such a nuisance. But they finally did
Disturbing
call.
people, disturbing the
Yeah.
residents.
Yeah. So they
Mhm.
called and they had it towed because it did not seem like it was being used. It seemed like it had been abandoned. They had it
Mhm.
towed, and the Houston Police Department actually ended up selling the car at auction.
Oh,
So she comes back from college and her
her
car
car's
is
gone.
gone. Yep. So we ended up paying her for the
Oh,
value of her car, which, you know, wasn't terrible because she was a young college student. They
yeah.
don't normally they don't drive Teslas, so that was good.
Yeah, that is an unusual though. Wow. And so the association didn't have record of her license
No,
plate,
they didn't
right?
have
They
record
didn't have,
of her car.
so
Yeah,
that goes
no,
to show you, it's important to keep good records. So they could have said, oh, that belongs to so and so in unit 12, and yeah, it would have solved the
exactly.
whole thing. Hmm.
Yep,
Yeah. That's an unusual one. That's definitely, I've never
that
seen that
wasn't usual. Yeah.
one. Hmm. And now we're going to talk about employment practices liability. And a lot of associations, Rachel, as you know, have employees. They have people working in the offices and they have security personnel, et cetera. And we saw a situation where an association had a guard for the front gate, and he was an older gentleman. He was 72, and they ended up terminating him. And basically, he sued for age discrimination. And because the association had more than 20 employees, it's subject to the Age Discrimination in Employment Act, ADEA. So, can you talk about that, about employment practices liability a little bit?
Certainly. And the majority of our um, associations, that there's usually a property management company that, you know, sort of has the staff that would take care of the security or take care of being a doorman or something along those lines. To the extent that there are associations that retain their own employees, um, yeah, the difficulty lies in the fact that they're typically not up on employment law, and it can be it's a lot to know. Um, what I would recommend is, if any association is going to hire their own staff, is to have an employee handbook that would set forth the expectations of both parties. You know what to expect of your employees, and they know what to expect if there needs to be a warning. It'll set forth how that will proceed. Um, and there was one other thing. Document your file. I know I said it
Ah,
before on another claim,
great,
but
great
yes,
point.
if you
Yes.
have an employee who is not doing what they're supposed to do,
Hmm.
document the file, because typically if an administrative complaint is filed, the first question the investigator is going to ask for is the file, the employee's file. And
Mm-hmm.
if you have terminated someone, you want the reason like glaring in that file.
Okay.
So, and you can do everything right. It doesn't mean there won't be a claim. I shared with Sherry that we had a claim where I think he was a doorman and he was let go because he was not performing
Mm-hmm.
the way he was supposed to. And he brought suit, and the association showed his attorney the video footage they had of him sleeping on the job.
Sleeping on the
And
job. Okay, that's
it
not
did go
performing.
away. It
Yeah.
when, the attorney
Mm-hmm.
was like, gotcha, and,
Mm-hmm.
withdrew it. But, you know, if not
Yeah.
for that footage, that could have been, a much messier litigation.
Right. Exactly. Yeah. If there's no documentation and no paper trail of what they've
Correct.
noticed or what the problems are.
Correct.
Mhm.
Another suggestion that I would strongly suggest is that the association have a central email that they use to communicate, that they not use their personal email accounts, which can become subject to discovery if there has been back and forth communication between the board about board business and litigation is filed. So that is, I would strongly suggest that the boards be encouraged to create an email system just for communicating about board issues.
Mm-hmm. Okay, that makes a lot of sense. That's great advice to track it. And if there
Mhm.
is a case, something comes to court, goes to trial, then you have, like you said, they can ask for the emails. And rather than having to give you a personal email account, I think that makes a lot of sense. Makes much more sense. Great tracking. Yeah. Fantastic. Great. And now I know a lot of you are wondering if we've seen any COVID claims. And actually, I'm just going to mention a couple of pieces of information about what we've seen. We've seen 12 COVID claims to date, and we've seen them basically from the state of Florida, Texas, Missouri, South Carolina, and Virginia. And the claims are kind of what you'd expect to see because we were talking about this a few months ago when we did a COVID webinar. They're stemming from closing the pools, the gyms, the tennis courts, banning Airbnbs, that type of a thing. So that just gives everybody an update on COVID as to what's happening in that claims area. And now we're going to talk about other claims that Rachel's seeing in the community association world and the industry. We talked about foreclosure already a little bit. Was there anything you wanted to add to it, Rachel, regarding wrongful foreclosure? No, we talked
I
about it
can't think
quite
of
extensively.
anything else to
Yeah,
add.
we talked about the two different types and what makes more sense in her opinion. And then we haven't talked about insured versus insured yet. And we have seen situations where a board has left and they've moved on and a new board comes in and they're not happy with the decision that the previous board made. It could be something like putting a new roof on or how they spent money to fix something, etc. And
Mhm.
insured versus insured is an area where we see a lot of claims.
Yeah, and it it can become pretty messy. The scenario of the new board coming in and sort of reviewing what the prior board had done and perhaps discovering some irregularities or um, things that they felt weren't done properly, enough bids weren't obtained before entering into a contract, or fill in that blank. um, and they file suit against the prior board for these actions. Um, Usually, in my experience, the current board is very upset to find out that this policy provides a defense to the prior board.
Really? Oh, now
And
that surprises. Yeah,
oh
that
yeah,
makes
and
sense.
the association is responsible for the retention. That
Mhm.
really burns them. So all of that needs to be sort of contemplated before moving into this kind of litigation. The other piece that we usually see is the people who are sued by the current board.
Mm-hmm.
It's not unusual for them, because this is their place where they live,
Mm-hmm.
and they have been on the board and usually feel like they have dedicated a great amount of their personal time. Um, when they are sued, they feel attacked and they feel like their name is being slandered. And it is not unusual for them to then counter with a slander and defamation lawsuit against the current board, which again triggers this policy, perhaps also a general liability policy. It may I should say it may trigger the policy for the current board. So then you
Mm-hmm.
have policies on either side of the V trying to sort of disentangle um,
Mm-hmm.
that litigation. Yeah,
It can get very messy. It sounds like it can get very
get
messy back and
very
forth,
messy, and
claims and
it's highly charged. It's, it's where people
emotional.
live. They're very emotionally attached. Absolutely.
Mhm.
This is their community. They know everyone around, and if they get sued, they feel like everybody knows, and
Right.
they
Mm-hmm.
feel attacked, and they're going to
It's a
respond.
reputation. Mm-hmm.
Absolutely.
Absolutely.
So,
That's why we
yeah.
talk about the non-monetary claims are really the most common because a lot of it is emotional
Oh,
and
yeah.
it's where they live
Asking
and
for an apology. We've seen
Mhm.
that many, many times.
Mhm. That would be a nice way to settle it. Just an apology. That would be
It's never
fantastic.
just an apology. It's usually a long list of things and an apology at the end.
At the
Preferably in public before everybody. Tell them that you were wrong. We were right. Like,
end. In front of the whole neighborhood.
exactly. So,
Great. And then the next one is architectural violations, which I had a situation in my neighborhood actually where I think I was telling you earlier where a neighbor was putting up a kind of a work shed, next to his house, and he had it probably like 75% done, and he was doing a
mm,
good job out there banging every day. And then all of a sudden the association said, whoa, you didn't get permission from us, etc. So he had to stop. He was really upset. I believe he resolved it so that he was able to go forward. But what do you see in this area, Rachel? Have you seen some situations where this is an issue?
certainly, we sort of, it can come in two different ways. You have people who bring their plans to the architectural committee and they're denied, and they are looking around their neighborhood saying, well, you let Joe down the street build a fire pit and you let Sue up the road build a fire pit. I want to build a fire pit. You're denying my plans. It's arbitrary and capricious. You're letting other people do it and just
It's
arbitrarily
not
deciding
fair.
I
It's
can't.
it's
Right.
not
It's not
fair.
fair. Um,
Hmm.
so litigation can come in that way. And then the other side of that is you're the neighbor, um, and you see, construction going up, and you are unaware of it, and it affects your view, and you're not happy with it. And some CCNRs, I'll go back to the CCNRs, state that if there is construction that is going to affect the aesthetic, that the people whose aesthetic it's going to affect get to be brought in. So the neighbors would get to be brought in to the process and
Ah,
have some say in it. And the claim I had, the CCNR said that, and they did not bring in the neighbor, and she was not happy with what they were constructing, and so she brought the claim. And so that came in as a violation of the CCNRs, but it was at its heart, a violation of the architectural
mhm.
process.
That's how it started. That's how it started
Mhm.
out. Interesting. Yeah, that makes sense to get the neighbor's approval if it's going to affect the neighbor in any way. That makes a lot of sense. Mhm. And speaking of affecting neighbors, another area that we've seen that we've seen all kinds of unusual types of complaints and situations pop up is noise, which you might think it could be barking dogs or a loud party or loud music, but there's lots of different unusual areas that you'd never even think of that could turn into a noise complaint. such as hardwood floors, for example.
Hardwood
That,
floors. Hmm.
mhm. And I know you saw a really unique one in New York City several years ago with elevators or with an elevator shaft, I
Yes.
believe. Hmm.
Yes, there was a person who had spent millions of dollars buying a beautiful apartment, and it was located next to the elevator shaft, and he could hear the elevators, and it bothered him that he had spent so much money and then was sort of having to deal with the noise of that every day. Um,
Hmm.
and that becomes sort of a battle of the experts. In New York, they have the noise code, what's allowed, what's considered to be excessive. So you
Hmm.
have, your experts come in and measure and determine that it's fine, and theirs come in and say it's not, it needs to be remedied. And, you have some of these are historical buildings that, to do that kind of renovation is very expensive. So they will make lots of attempts to try to remedy it without having to sort of rip it all apart and redo it. But
Hmm.
yeah, that becomes very uh,
Very involved.
expert. It's
Yeah,
their
didn't
expert
even
and
know
your
there were.
expert.
I didn't even know there were noise experts until
Oh yeah,
we talked
acoustic
about this
experts.
plane.
Hmm.
Hmm.
Noise and
Incredible.
vibration.
Noise
Oh yeah.
vibration.
Hmm.
Vibration. Wow, incredible. And then I know in a lot of older buildings that have been converted to condos with the beautiful hardwood floors, the squeaking became an issue for a while, and people living below a hardwood floor. You know.
Yeah, they would.
Hmm.
That usually comes in as the board failing to enforce the CCNRs, because typically the CCNRs would set forth that you need to have usually about 80% of your floor needs to be covered with the rug, to
Hmm.
sort of, cancel out the noise. And if the upstairs neighbor hasn't done that, the downstairs neighbor usually goes to the board and says, "Hey, I'm hearing them walk around. They don't have their rugs. They're in violation. Do something about it." And the board can, send multiple letters, but if it doesn't get remedied, um, the board usually get, the board usually gets brought into a litigation alleging that they're failing to enforce the CCNRs, and it usually also has a breach of the warranty of habitability. Um, they'll allege that it's impossible for them to um, peacefully enjoy their unit.
Mm, interesting. Wow. Yeah, so that's another complex claim and complex situation, complicated situation, I should say. So noise complaint is another area that we see a lot of claims in. And now we're going to talk about some common policy exclusions when you're shopping for a D&O policy and you're talking to your customers about D&O. There's some exclusions that you should be aware of that we've talked about a lot of these claims already, actually. Just be aware, just take a good look at the policy to see if it has one of these exclusions in it, because it's not a good thing to have it in it, because as we mentioned earlier, there are a lot of claims in these categories. So there's non-monetary damage exclusions, there's noise exclusions, we just talked about that, discrimination, employment practices, insured versus insured, and breach of contract. I mean, these are pretty important exclusions, I would say, not to have. Don't you agree, Rachel?
Absolutely. And it's
Yeah.
true, there are policies. I mean, the traveler's policy, this is included in it. Um,
Mhm.
I think to, find out that breach of contract isn't covered, and I should clarify, when I say it's covered, I mean the defense of the breach of contract is covered, not if there was a judgment of it wouldn't be indemnified, the damages would not be indemnified. But there are policies that don't even provide a defense for the breach of contract. So yeah,
Mhm.
definitely to be aware of what language is in the other contracts, other
Mhm. With
policies.
great, fantastic, thank you. And now we're going to talk about the risk management helpline a little bit. This is a helpline which can be accessed by any current travelers insured who has a community association management liability policy. And this is actually 1 free hour of advice. And the phone number is up on the screen right now. It's 855-548-8656. And it's a legal professional, Cole, Scott and Kazane, a law firm. They'll return your call. They'll discuss the matter. If you have a concern about whether something looks like a claim, you think it could turn into a claim, they'll basically give you 1 hour of free consultation. And this is a great resource for your customers. So again, if you'd like today's PowerPoint with this phone number in it, please download it from the handout section. And this is the risk management helpline provided by Travelers, and it's free Monday through Friday, 8 to 5.
I
And
believe that
then,
number is also in the policy,
okay, so it's
within
in the
the
policy.
pages of the policy. Yeah.
Great, great. And then the next number that I have up on the screen is our claims hotline number, which is 800-842-8496. So that's the hotline to report any claims. So thank you, Rachel. Thank you so much for a great webinar. Thank you for
Thank you.
lots of fantastic information. And thank you everybody for joining us. Again, I record all of our webinars and I put them on our website, which is kdisonline.com. And please join Kevin Davis and myself on October 22nd as we talk about what is social inflation and why is it causing D&O rates to rise. Thanks, Rachel. And thanks, everybody. Have a great afternoon. Take
Thank
care.
you.
Thank you.
Bye-bye.
Bye.